Good evening. This is John Milburn for Environmental Law. This is week 11, and primarily this week we're dealing with challenging environmental decision making. Now that can be a couple of forms. One form is where we are representing people that are involved in a council and they are dealing with an application and they're being challenged in relation to their decision. Or down the track it might be acting in the role of a council who has cause for complaint in relation to something that has happened as a result of a previous decision. It may be that we're acting in the challenge on behalf of a developer who's unhappy with the terms of conditions or the rejection of an application, or it might be that we're dealing with submitters, people that are objecting to circumstances. So we've got a couple of people, the regulars online, so thank you for joining us again. So tonight we'll go through a few pieces of information that might be relevant to the final assessment. I'm going to start with some brief discussion about, if you like, the role of the Environmental Defender's Office. The EDO has some terrific resources. It has a quick reference checklist, both in terms of before proceeding to litigation and a quick reference checklist in relation to the litigation itself. Yes, John?
Point of order, but no money.
No money, but for the EDO? Yes, the EDO do rely on contributions from interested parties, some government bodies, and yeah, it's always an issue in relation to money. But in terms of information on their website, there's some terrific material. And as I think I've mentioned before, if you could consider buying their book, their publication, it's pretty cheap, and that will help them as well and help you in dealing with environmental law issues. So keep that in mind. Now tonight, as I mentioned, we're going to look at challenging environmental decision making from the different perspective of maybe councils, developers, or objectors. So some of these things are common between them, and one is that people will often want an injunction. An injunction is, if you like, an order of a court, and it's made on application. And any one of the parties that seek to challenge decision making can apply to a court for an injunction. However, there are different types of courts, there are different types of injunctions, and we need to understand the basis upon which we're going to ask the court for the injunction and proceed from there. Let's talk about the types of injunctions. In essence, there is the interim injunctions or temporary injunctions and the final injunctions. And sometimes you can go to court and ask for both. On an interim basis, the idea is to protect the current situation. You know, you may be familiar with that term status quo. And the idea of having an interim injunction is to maintain the environmental situation until the court can make a decision. And that is typically going to be the subject matter of the application proper. And the application proper, the formal application that you make, might be for a permanent injunction. So in the same application, you might be asking for two injunctions. One temporary until we have the final hearing, and then at the final hearing, a permanent injunction to stop something from occurring. When the court considers the interim injunction, it does so by asking two essential questions, and they are, is the person asking for the injunction able to put forward an arguable case, a prima facie case, and is there a serious question to try? And when they make the decision, and I see my internet connection is unstable, when they make their decision, Suzanne, hi, I'll just get you to mute your microphone if you would, Suzanne. Thanks. But feel free to ask a question as we go. That's great. Thanks, Jace. The court will consider what's called the balance of convenience. So they're going to assess the relative interests of both parties to the litigation and determine whether the applicant, or more likely the environment, is likely.
Sorry.
Yes, John.
I just thought that's a different one.
What's
Balance
that?
of convenience, not the
Balance of
balance,
convenience. Yep.
not the balance of probability, or what's the other one? There's another, of course.
You're talking criminal beyond reasonable doubt.
Beyond reasonable doubt,
Right.
but
Okay.
balance of convenience.
No, balance of convenience. So balance of convenience is the term that we use when considering whether a court should give an interim injunction. And they'll weigh up the likely irreparable harm that might be caused. They'll consider the question of damages and the harm that, to the environment. So there's a whole lot of things that might be considered. Now we need to ask. Yes, John. Yes, John.
And which court is this?
Yes, well, actually, that's the next point. So if it's a federal matter, if we're dealing with something under the EPBCA, which court do you think we'll be applying to obtain our injunction?
It must be the federal court.
Very good. Federal court. That's it. And this is bonus points. This is a tough one. Do you know what section of the EPBCA you would consider and rely upon when making an application for an interim injunction?
No.
A good, clear answer. 475. So make sure that you're aware of 475, and it deals with a few circumstances, and essentially it provides that if someone has engaged or proposes to engage in conduct which is in contravention of the Act, then a person can apply to a federal court for an injunction. So it's pretty simply worded. And the injunction can be prohibitory, meaning to stop something from happening, either on an interim or a permanent basis, or it can be mandatory, which is to force someone to do something. So they're covered in various subsections of 475. Subsection 5 deals with interim injunctions, and that's where the court must consider whether to restrain someone from doing something until we have the final hearing. Now, can anyone go to the federal court and complain about any action that is an alleged contravention of the EPBCA, and the court will listen to them?
Only if they have standing.
Very good. Very good. Okay, so we were listening a couple of weeks ago. Standing, exactly. Have a look at subsection 6, subsection 7. Yes, John?
I was just motioning. I was listening a bit.
Only a little bit. Okay. Yeah. Thank you. All right. So tonight we want to just have a look at a sample case. It was called Booth against Bosworth. It's 2001 Federal Court of Australia 1878. It's actually in a few parts, Booth and Bosworth. The citation I've given you, 2001 FCA 1878, deals with the interim injunction application. So in that case, the matter went before a federal court judge, and the case involved the issue of flying foxes. What had happened is that Carol Booth, the applicant, sought to restrain Ronald Bosworth from engaging in conduct which she said was contrary to the EPBCA. And as a result of that, she had to establish standing, and she had to then argue on the balance of probabilities that an interim injunction should be granted. Now, ultimately...
Excuse me, John.
Yes, John?
Excuse me. Well, there's my hand. Oh, there we go. What was her standing? What interests me? If he's on the border of the national park and he's doing that, where is she?
Yep, that's a very good point, and that's the preliminary point. So just to explain that, put it in context, what was happening is that she wanted to restrain Mr. Bosworth from causing or procuring or allowing the death or injury to flying foxes through electrocution or shooting or otherwise. And she sought this prohibitory injunction to dismantle devices on the property that were used for killing the flying foxes. Essentially, they were being electrocuted. So you're right. The first thing that the court wants to know is, what is your standing? And ultimately, Justice Spender decided that Dr. Booth did have standing because it was apparent from the material that she was a person who was well known for being involved or concerned about the well-being of flying fox population in the wet tropics area, which was a Commonwealth area. And it appears that she had been involved in policy documentation. She did voluntary work for North Queensland Conservation Council. She was secretary of various bodies that were environmental law based. And as a result of that, the court said, yes, I'm satisfied. If you look at section 475C, that Dr. Booth does have standing, does have this special interest. Yes, John?
So because she was a doctor and all sorts of things, she has some credibility, but a normal person may be looked upon a little differently?
So you don't need to have a doctorate in order to satisfy that test, but you need to show that you've got more than a passing interest, I think is a fair statement. And she was able to establish that in those circumstances. Now, bear in mind, of course, different locations have different rules. In New South Wales, in the state jurisdiction, you don't have to show standing. Everyone has standing. In Queensland, the rules are different under the Queensland legislation as well. But in the Commonwealth jurisdiction, for this type of injunction, look at 475 subsection C. Okay, so that leads us then to the legal issue in that case. And the substantive matter related to what Dr. Booth said was an alleged breach of section 12 of the EPBCA. And essentially, section 12 provides that someone can't take action that might have a significant impact on World Heritage areas. And there are civil penalties that apply to that. And in fact, the Crimes Act, section 4AA, can apply in those circumstances as well. So the question for the court was whether there was likely to be an action by Dr. Bosworth that satisfied those elements of section 12. You see, when you go and ask for an interim injunction, you have to show that there's essentially a good case, a strong case, and then talk about the balance of the convenience that we mentioned before. So when you're thinking of, if you're approached by a body of people that are planning on taking action, for example, and they know that you've done environmental law and they say, well, you can be the person in charge of coordinating the litigation, they might ask you to stand in front of the hall and give them a rundown as to what's necessary. And just saying, oh, we'll engage a lawyer at $1,000 an hour to give you the proper answers, probably won't cut it at the start. So you're going to need to know some of these basics in that situation, or more immediately for the exam, perhaps. So in this case...
Sorry, John.
Yes, John?
Could you rephrase that?
What I'll mention is this, that when it comes to the take-home exam in 11046, you will need to know how to deal with one of the three potential scenarios that we're talking about tonight. The three scenarios are: you are called upon to assist a group of objectors who want to challenge decision making, or you're called upon to assist a council that wants to challenge something that is not right, or you're called upon to assist a developer who wants to challenge a decision that's been made adverse to its interests. So one of those three. And
so these are essay questions.
No, problem-solving questions.
Problem solving.
No, the take-home exam in 11046 is a problem-solving question. So it'll be a scenario, and you have to provide the solution. So we're dealing now, at the moment, with the first of those scenarios, which is where you're essentially acting for the objectors. So before you go to court, you need to gather your evidence. And that's what Dr. Bosworth did. She essentially did a bit of a stakeout. They went to the farm. They saw the flying foxes there. They drove to the property. They did some spotlight beaming. They then went to the same grids the next day. They counted the number of bodies that were on the grid, on the ground, etc., and then left at 6:40 in the morning. So she was there pretty much on a stakeout all night. So, in other words, you need to have cogent evidence before the court and not just conjecture. So, in that case, ultimately, both parties had impressive expert evidence, and the court declined to make the interim order. But part of its reason for doing so was that the matter was going to be heard quickly down the track by way of an application for permanent injunction, which was granted by a different judge. So the court noted in rejecting the application for the interim injunction that the financial loss to the respondent that he wouldn't be able to recover at trial on the balance of competing interests was such that it would be appropriate to decline to make the interim order. Now, the final decision...
Sorry. What you just said there is just... could you rephrase that?
Yep, sure. So what happened is the court had to consider whether to make an interim injunction which might last for, say, 6 months. So it came on urgently, but the court listed it to move quickly through the system. And the court said, no, we're not going to stop Mr. Bosworth, at least at this stage, because in part, Mr. Bosworth would lose a considerable amount of money if they were to grant the injunction at that stage. So essentially, he was able to continue with the action until the matter went to trial, which was in about 6 months' time. And at the final trial, Dr. Booth was successful. Now, the final trial is reported in a separate decision, which is 2001 FCA 1453. And in relation to the permanent injunction, the court accepted that it was probably not economically feasible for the respondent to immediately protect the entire orchard from netting. And there was evidence that was put forward in relation to protecting the World Heritage values of the area. And the decision of the court was that an injunction should continue, but it allowed some degree of flexibility. In other words, the injunction was conditional. And the matter had to then be approved by the Minister for the Environment. Now, there is a bit of a footnote to that decision. One of the farmers applied to the federal court to have the injunction removed because this then had a widespread effect. And the case was Bosworth against Booth, 2004 FCA 1623. And Justice Kiefel, as she was then, she's now our Chief Justice, refused the application and said there's no basis for a new trial. There's nothing that can be agitated now that wasn't agitated then. If you have some new arguments now, you could have brought them at the time, which is what we call anshun estoppel, and the matter shouldn't proceed any further. Okay, so if you want to get an idea of how to go about galvanising the ranks of objectors in relation to a Commonwealth environmental issue where you seek injunctions, then Booth and Bosworth is a good case to consider and keep up your sleeve. It shows what the court considers and it talks about the procedures as well. Now let's look at a different scenario. Let's look at a scenario where we're acting for, say, a developer who wants to challenge a decision at a state level, or a council that wants to challenge a decision at a state level. So here we're dealing with the Sustainable Planning Act.
Excuse me,
Yes,
John.
yes, John.
Say we're acting for a developer. Do you mean we're the legal team that's on the developer's side?
No, put yourself, well, not necessarily yet, more a case of the scenario where if you're on the council or you're in the development company, you're one of the personnel that management will look to for expert advice as a precursor to engaging lawyers. So the question that I have for you in the exam will be posed to you on the basis that you're not lawyers, you're not to answer it as lawyers, but you're to answer it on the basis that you get that knock on the door saying, we think that this might be an environmental law issue. You know something about environmental law. Before we engage the lawyers, tell us what we need to do to prepare. Do we engage lawyers? Give us some idea of what action we could take or what court, length of time, procedures, things of that nature.
Given that they're trying to save that environmental asset. Is that what you mean?
Oh, no, now we're talking about a different scenario. So in the first scenario, yes.
So the people that have come to you, you're saying that someone comes to you and has an issue, but you're not trying to save it. Sorry, I don't get it.
Okay, I think you may have missed this bit at the start, but what I'm really doing is posing 3 general scenarios to you, and these are the sort of scenarios that you might have in the exam. So the first one that we dealt with, which is a scenario where you're asked to be the head person of a group of objectors that essentially want to take action against some environmental issue, a Booth and Bosworth type situation. And you have to tell others what you think should happen, how you go about dealing with the scenario. In other words, pointing them in the right direction. That's the first scenario.
So you need evidence for that one?
Yes, exactly. Yeah, absolutely. Well, as it turns out, you need evidence for all of them, the 3 scenarios. So that's the first scenario. Second scenario and the third scenario, I'm really doing them together because they're both state-based scenarios, and that is circumstances where you might be working, say, for a council, and the CEO says, we have this situation, give me some broad direction. Or it might be that you're working for a development company and the CEO knocks on your door and says, give me some broad direction. So in both those scenarios, we're talking about the state jurisdiction to contrast it to the federal jurisdiction, which was the first one.
And how would you be pointed in that direction?
Yep. So we now look at the Planning and Environment Court as opposed to the federal court. So the P&E court is state-based, it's district court level, and it deals with state legislation. The first thing is that under the Planning and Environment Court, you have some information which is available to you on the website. I can't share it with you because just before you arrived, my second screen disappeared. It's black. I can't use it. So the lovely website links that I was going to give you, I can't give you. But what I'll do is I'll just encourage you to have a look at the Planning and Environment Court website, and you'll see there some good information about proceeding through the P&E court and some very good information about alternative dispute resolution. Alternative dispute resolution, or ADR as we call it, is a very important component of Planning and Environment Court litigation. The court encourages ADR procedures. Those procedures are generally organised through the court. They're generally free. People are ordered to attend. It's mandatory. And the ADR registrar has considerable power to make orders. And almost all the disputes are resolved before a hearing anyway. So in some ways, from a practical point of view, knowing your way around the ADR processes is more important than actually doing the litigation, because statistically that's where you're going to end up most of the time, dealing with the ADR process. So have a look at what the... Yes, John?
Sorry. That's also the land court, isn't it?
Yes, the land court has ADR process as well, absolutely. I'm not including that as one of the scenarios that we're dealing with tonight, because I'm trying to restrict it to scenarios that will be on your take-home paper next Wednesday when I release it. But you do need to know about the state-based ADR process. So the best thing I can do is refer you to the website, which has some really good information, and it'll tell you about the powers of the ADR registrar. It'll tell you about the case management conferences, the without prejudice meetings between the parties, and also the experts meetings, which are conclave meetings chaired generally by an ADR registrar.
John, can I write that straight into my essay and quote you?
You can. That'd be fine. All right. So when you're asked to give some advice for the developer or the council, they may say, how long is this going to take? What are the broad strategies that we need to consider? You can say, almost certainly, even if we file in the Planning and Environment Court, we're going to be involved in mediation. If you go onto the ADR website, you can actually see the registrar's calendar, and you can see lists of availability for the calendar for the ADR registrar. The other thing... Yes, John?
So does this mean that, like, for these cases that get towards a judge, that as another way out, they try to mitigate it with what are we just talking about? What's the
ADR?
Yeah, sorry.
Yeah.
And they try to get around having to go to court by having that process.
No, don't think of it as being a way of getting around court. Think of it as a process that's absolutely integral to the court procedures. So invariably, if you file in the Planning and Environment Court, very quickly a couple of things will happen. And very quickly, you're going to be faced with the need to have directions orders in place, to file material and involve yourself in mediations. So what I'm really asking you to do is be aware of those processes so that you can explain that in broad terms. Yeah, sorry, John?
You said file material.
Yeah, I guess that's a lawyer's term. Sometimes these lawyers' terms just flow off the tongue. But an example of material would be affidavit material. So so not soil, not that sort of material, but paperwork. So you'll need to get an idea of what sort of material, what sort of paperwork is filed at the Planning and Environment Court. So it might be, an application, it might be affidavit material, it might be expert reports, it might be draft directions orders for mediation, etc. So that's what I mean by material. So thanks for raising that, John. Sometimes I forget. You just become so used to the terminology.
You forget that we're stupid, we're not lawyers.
No, yeah. Not at all. I forget that we have our own little terminology. All right, now the thing is, when you're looking at the Planning and Environment Court, I would like you to be aware of a couple of things. The first is that the court runs based on its own rules. So there are Planning and Environment Court regulations, there are Planning and Environment Court rules, and also practice directions. So the Chief Judge will from time to time make practice directions, and have a look at practice direction number 2 of 2011 of the Planning and Environment Court. It's not hard to find. You should be able to find that quite easily. If I had my other screen, I'd pop that up on the screen. But the purpose is to set out the case management procedure.
Sorry, John.
Yes, John?
What do you mean by practice directions?
Yep. So the Chief Judge says from time to time, through a practice direction, this is the way we do things in this court. You need to file 3 copies of material. You need to be available for a first mention within a certain number of days. You need to have your affidavit material filed within a certain number of days. We expect a mediation to occur within a certain number of days. So it's really important to look at the practice directions, because when someone knocks on your door and says, how does this work? If you've read and understood and have handy the practice directions, you can speak with real authority and say, oh, look, in this court, in this jurisdiction, this is the procedure that you're likely to face, and this is a rough idea of the time frames. And they'll say, that's good, you're really on top of this, because you know where to look. You need to look at the practice directions. So there are quite a few practice directions, but I'm going to ask that you find and read and have available for your take-home exam. This is for 11046. Practice direction number 2 of 2011. That sets out what you like, the case management procedures. And
sorry, John.
yes, John.
Where do we find that?
That's for you to find. That's for you to find. I could show you on the link. I was going to show you on the screen, but look, I'll just, they're pretty easy to find through the P&E court, and what I might do is upload them for you as well. But you should be able to find them. But just make a note of which one's at the stage. Are you looking for it, John?
Which ones were they again? Which ones?
Yep. First one is practice direction number 2 of 2011. So it's practice direction number 2 of 2011 of the Planning and Environment Court. And it sets out the case management procedures. And for example, it'll say, look, an application for directions. Directions are the orders of the court saying, this is going to be done by whom, by when. So like a checklist saying, okay, we're mapping out now the litigation, so we all know what we're doing. So that application for the directions has to be made within 3 months of instituting the proceeding. So it happens pretty quickly. And I guess one of the points that I'm going to make is that before you start your litigation, you've got to have everything lined up, because there's not much time when you're involved in litigation in planning and environment court to get things ready. You've got to have it ready to go. And part of the reason for that is that a philosophy of the court is the just and equitable resolution of matters at a minimum of expense. So the court isn't going to waste time. It's not going to let things drag on. Not in this jurisdiction.
So they have no time for silly people that can't get their act together.
Well, they won't be happy with you, that's for sure. And even as a self-litigant, you're expected to have done some research, and you've
but even if they have a case, because they're incompetent,
Oh no, I wouldn't say that. No, the court certainly does help people through, but you've still got to respect the process and be aware that it's a very busy jurisdiction, and that the court can only help you so far. And it's not a matter of going to the court and presenting bundles of material, essentially with an offer to the court. Look, here's the material, make of this what you will. You've still, even as a self-litigant, you've got to respect that there are rules, and you've got to respect that it's up to you to make a case, even though the court will help you. And the best way to do this is just know these practice directions, because then you'll be better prepared for what's likely to happen down the track. When it comes to the ADR process, the practice direction I want you to have a look at is practice direction number 8 of 2014 of the Planning and Environment Court. And you'll see there that it talks about section 491B of the Sustainable Planning Act. That's another section you need to know in this context. And you'll need to know about Rule 19 of the Planning and Environment Court rules.
And sorry, John.
Yes, John?
And what do they say?
Well, the practice direction, firstly, talks about the purpose, which is to provide the ADR registrar with the ability to exercise certain powers to make orders and make directions. So the ADR registrar actually has the power to make certain orders. The second thing is that at the ADR, the practice direction talks about having a conference between experts. We call it a conclave. And the idea is that this without prejudice conference between the experts is designed to have them determine what they agree upon, what they disagree on, and why they disagree. So this is part of the practice direction, part of the ADR process. And then, of course, the ADR registrar makes certain orders to progress the matter through that process. So have a look at that practice direction as well. And I'm going to ask you to look at, just make another note of one. So there are not too many. I think this is the last one. Practice direction number 7 of 2013. Now, this is more for the issue of if you've got a council situation, it's a way of resolving early disputes that relate to infrastructure charges or development approval conditions. And it also relates to section 491B, subsection 2 of the Sustainable Planning Act, and rules 4 and part 5 of the Planning and Environment Court rules. Did you get all that, John?
You're kidding, aren't you?
No, these are easy. But the point is, the exam becomes easy if you've got these tools ready to go. And the idea is that when you read the practice directions, I'm sorry I can't show you on the screen.
But how do you have these tools ready to go? I mean, every minute you're giving us another case, how do you have them ready to go? I mean, what do you study?
Yep. I know there's a lot, but law is like that. Unfortunately, there's just a lot of reading in law. Also, there are some tricks to it. So part of the trick is knowing some of the material that's less obvious. I mean, I don't think, as good as Bates is, I don't think it's as theoretical. I think it's not as practical as it should be. And I mean that as a genuine constructive criticism. So what I'm trying to do is supplement all this theory that you've got here with actually what you need in practice. And I'm telling you what you need to know in practice, if you're going to even consider approaching the court, is you've got to know the relevant practice directions and be aware of the rules. So if you're asked that difficult question from a CEO, for example, about what we can expect in this litigation, if you start talking about the precautionary principle, ecological sustainable development, and treaties that were signed through the Rio Declaration, etc., the CEO is going to say, no, don't tell me about that. Tell me what I need to know. What am I actually facing? That's when you'll say, I'm very pleased that John told me about these practice directions, because that's the nuts and bolts. I hope that makes sense, John. But I do appreciate this a lot.
No, that's a very good answer. I like that one. That's one of the few things I've liked.
Thank you. All right. Well, we've got to. I need to have people give me feedback, so I need to have more of those likes. Right. So have a look at those practice directions and be aware that there are those rules. I'm sorry I can't show you on the screen, which I plan to do, but you'll find that with the exception of one of them, it goes for about 3 pages. The others are pretty straightforward. They're not hard reading to do, and I will provide the links on Moodle.
Sorry, what was that again? What was that for? What was?
for the practice directions. So
Oh, okay,
I'll
sorry.
provide you the links for those practice directions, but you should be able to find them really easily anyway.
And they're all the Planning and Environment Court. Is that?
Yes, yes. So I haven't told you about any practice directions for the Federal Court. I just thought I'd restrict it to the Planning and Environment Court.
Okay, that's good.
Okay. But for the take-home exam for 11046, just remember, of course, that there are a number of different options that are available to regulators if you're going to challenge something that you're not happy with. And it goes beyond what we've talked about tonight. It covers probably the last 3 or 4 weeks where we've talked about enforcement orders, administrative notices, injunctions, criminal proceedings, etc. Likewise, for a developer, there are other issues that you need to consider, but mostly it's a matter of looking at the Planning and Environment Court option and then having a section of the Act upon which you can rely to say, this is the section that we put forward as to support our argument for this type of this order that we seek.
So what's a good section?
Well, we've mentioned a few tonight, but I think 601's a good one to have a look at. There's a few around. And I'm talking the state level. In the federal level, what did we talk about tonight? Was it 475? So I think we talked about, I can't remember the numbers just off the top of my head. I'm sorry. If I start trying to remember the numbers, I'll give you the wrong numbers.
I can give you a few wrong numbers too.
All right. Okay. Well, that then brings us to the end of our course. We've got the take-home exam for 11046 that I will release at about 6 o'clock next Wednesday. You'll see that through Moodle, and I think you've got to upload your answer in the usual manner by 11:45 p.m. the next night. So you've got just over 24 hours. Now, here's the bad news. I've set the computer to say it will lock you out if you're late. So please don't be late with it. If it's getting to within 15 minutes, just give me what you've got. Don't risk it, because there might be some technical issues, or there might be a lot of people trying to throw things on the Moodle at the same spot. You should be able to answer the question within 5 or 6 hours. Would be really good. Possibly less. You might be able to answer it in an hour.
That's if you know what you're doing.
No. If you're well prepared, you might be able to do it in 2 or 3. But, I mean, I would personally enjoy the process and not rush it. If you've got the time to do that, then take the time and, think it through. But it will be, it's in 2 parts. The first part, this is for 11046, is a problem-solving question along the lines of the sort of thing we've discussed tonight. And the second part is an essay question, nice and straightforward. Yes, Jace, did you have some question?
Have you got any idea about how long, as in word count, roughly, that this might turn out to be?
Yep, from memory, 1,500 for part A and 500 for part B, from memory. It's quite short.
So sorry, Jay. So 1,500 for 20%, and for the 3 questions out of 5, something less.
No, look, have I given you? I've given you some wrong information on Moodle. It may have been a past offering of the course. So
my understanding from Moodle is 20% for 1 question and 10% each for 3 questions out of 5.
Yeah. No, sorry. For 11046, I'll just explain. The take-home paper, which is for 50%, only has 2 questions. So I'm sorry, that information that's aged information, I think. You've got 2 questions. Part A is a problem-solving question. That's worth 35. And part B is a essay-style question. That's worth 15. So there's no choices in this one.
Oh, sorry, John. The information on the site is wrong.
Okay, I will try to correct that straight away. I'm sorry. Whereabouts is that incorrect, John? Is it in the unit profile? Is it in the?
It's in when you click on the final exam, like in the assignments 1, 2, 3. You click on the assignment,
okay.
and it says 20% for 1 question and 3 questions out of 5 for 10% each.
Right. Okay. Sorry, I've changed my mind on that one. So it is a 35 and a 15. I'll make that change, but thank you so much for bringing that to my attention. So we're right with that? Yes, Jace?
So what's it? 35% for problem solving, that's what you said,
Yeah,
and 15% for an essay question.
That's it. Yep.
I hate essay questions.
Well, I know that you will enjoy the problem-solving question. I think the problem-solving questions are much more relevant. So I'm glad that you said you're not too keen on the essay-style questions. Yes, Jace?
With the words that you talked about, is that an actual set word limit where we can't go over or under, or
No. Look, I don't mind if you go over, say 10% or so. I won't even bat an eyelid at that. If you go more than that, I then start to look at it a bit more critically and say, well, did you really need to go there, or are you just adding things in that are wasting my time? And I don't like to be wasting my time. So I hope that gives you a good hint.
One point, do we need to reference?
Yes. In the exam, in the take-home exam, you do need to reference. The same rules apply, same sort of referencing, and what you put in the footnotes doesn't count towards the final word count. So you can...
one thing I meant to ask you that on the assignments, do passages in inverted commas that are referenced count towards the word count?
They do. Yes, they do. If it's in the body of the text...
I thought they did not.
No,
I thought they did not. Same as only substantive words. So when you're doing the word count, and the and but and etc. are not counted. Similarly with inverted comma quotes.
No, I count all of those if they're in the body of the text. If they're in a footnote or they're in a bibliography, then I don't count them as part of the word count. But again, I'm not too strict on it.
That means I went over on the assignment. I counted as they don't count.
I've looked at your assignment, and there was no deduction for the word count, so don't worry about that. The assignments for the second one were really good. I'm very happy with the second one, so it was good across the board. But they're easier than what
we expect to mark before the exam starts?
Yeah, you will. I aim to release the results on Sunday. I mean, I haven't completely finished the marking process, but I'm almost there. But I don't like to release the results until the final cutoff. So the final cutoff for people that haven't lodged their paper is this Saturday night at 11:45 p.m. 11:45 p.m, that's an absolute cutoff. Try to lodge it on Sunday, you'll get 0. But it means that I can then release the results and give some feedback on Sunday. That's my plan. That's if everything goes according to plan. So that way, I'll also tell you where you sit leading into the final exam. Okay. And I am going to...
I've finished all my other assignments. I've put the last one in today. I've got 5 days left to study the law, and
Good.
I'm not quite sure how much wiser I am after this evening.
Oh, it'll all come together. I'm going to correct the information that is incorrect on Moodle in relation to what the final exam is for 11046. It is, as I said, in those two parts. And I will upload a link to the practice directions that you should keep handy. And as you read during the next week and prepare, I want you to have a practical focus, thinking, how do I actually apply this in practice, in a real life situation, as if I've got that knock on the door that I've been talking about. Okay?
Sorry,
Yes,
knock
John?
on the door. Who?
The knock on the door, yes. So if you get the knock on the door from the CEO saying, tell me about this, or you get the knock on the door from 50 potential objectives saying, lead us, tell us what we need to do to stop this development, then you're going to be the one that provides the answers. You're not going to be the one who gives the final answer. That'll be for the lawyers.
Which document would you go to first off to go, oh shit, they're asking me what I need to do? Where would you go first?
Honestly, I would go, if it's a state, I'd go to the Planning and Environment Court website. It's terrific. It's got some great material, and it will help you to get a good feel for the litigation process. That book is excellent as well, but it's more for the objectors. Not going to help you so much if you're for the developer or for...
It just gives you a nice flow chart to cut and paste.
Yes, yeah, flowcharts are good.
And it gives you a definition of impact accessible, which is good in assignments.
True, exactly. All right. So I'll do those things, and in return, we'll provide you with the paper next Wednesday for 11046, for 19038. They're well and truly into it now for their final assessment. Okay. Any questions before we wrap up?
No, thank you, John. It's been an absolute pleasure, sir. Thank you.
Thank you. And no broadcast next week. So you get next Thursday night off. Give you a chance to get your take-home paper done. All right. All the best.
Yeah, it'll be a big night Thursday next week, that's for sure.
It will be.
Wednesday night. Wednesday night's the big night.
Oh, is Wednesday night State of Origin?
No, it's released on Wednesday night.
It is. But no, I just realised that, didn't I? So I've said I'm releasing the paper in 11046 an hour before kick-off for State of Origin. That's nice of me, isn't it? That's very cruel.
Well.
That's the way it is.
Yeah, but rugby league's a bit of a stupid game anyway. So.
Right, let's not go there. Okay. All right, all the best. Thanks very much for your participation, and good luck with the final assessment. See you then.
Thank you, John. Cheers. Bye.